Disclaimer: this video is for educational purposes only and does not constitute legal advice. Immigration law is complex and individual circumstances vary. Before making any decisions about your visa application, please seek advice from a qualified immigration specialist. Akbar Immigration Law Chambers can provide tailored advice for your specific situation. If you're planning to settle in the UK, you need to hear this. The Home Office just introduced a rule that could delay your settlement by 10 years. And most people don't even know it exists. What's the 10-year rule? Under the new Part Suitability rules, if you have certain suitability issues during your qualifying period for settlement, you'll be refused settlement. But here's the catch. You can only overcome this refusal if you've completed a continuous qualifying period of 10 years with permission and 5 years of continuous residence after the suitability ground came to the Home Office's attention. That's a 10-year penalty. What triggers the 10-year rule? The rule applies if you have any of the following during your qualifying period: a sham marriage or civil partnership, using false documents or information, deception in your application, breach of your visa conditions, debt to the NHS over £500, litigation debt owed to the Home Office. If any of these apply to you, you're looking at a 10-year wait before you can settle. Why is this a problem? Previously, you might have been able to overcome these issues with strong evidence of rehabilitation, character references, or proof that your circumstances have changed. Now there's a hard 10-year rule: no exceptions, no discretion. And the 10-year clock doesn't start until the Home Office becomes aware of the issue. So if you breached your visa conditions 3 years ago, but the Home Office only finds out today, your 10-year clock starts today. That means you could be waiting 13 years total before you can settle. Who is affected? Anyone applying for settlement under any route. Partner visas, child visas, parent visas, long residence, private life, family life. If you have any of these suitability issues, the 10-year rule applies to you. What you need to do before you apply for settlement: assess whether you have any suitability issues. Do you have a history of overstaying, previous visa refusals, any breach of visa conditions, any debt to the NHS or Home Office? If yes to any of these, you need specialist advice before you apply. Don't assume you'll be fine. The consequences of getting this wrong are serious. Book a consultation with an immigration specialist who understands the 10-year rule and how it applies to your circumstances. We offer a free 10-minute consultation to assess your situation. If you're planning to settle in the UK, you need to understand the 10-year rule. Subscribe to this channel and hit the notification bell for more updates on how HC 133 changes affect your visa. Book your free 10-minute consultation using the link in the description. We'll tell you exactly where you stand and what your options are. This is too important to get wrong. The 10-year rule is real, and it could affect your settlement. Don't leave it to chance. Get advice, get informed, get settled. We're here to help. See you in the next video.